Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Several months back, we talked about non-compete agreements and how the Federal Trade Commission had ostensibly outlawed them. That, as you might well imagine, has been challenged in court, so the ultimate outcome on that is still up in the air. In the meantime, challenges in courts continue on non-compete agreements between people. As I have mentioned several times, non-compete agreements have to be reasonable as to geographic area, time, and what kinds of competition are prohibited. For example, if I worked for a company selling durable medical equipment, like wheelchairs, walkers, oxygen concentrators, CPAPs, right? And I got trained on all the things I needed to do and sell that. And then I opened up a competing shop across the street that sold those things. That would clearly harm my employer. So they would have a right under a non-compete to stop me from doing that. However, if instead of selling durable medical equipment, I sold nutritional supplements and perhaps disposable equipment like tubing or gloves or masks, that sort of thing, well, then I'm not really selling durable medical equipment. I'm selling reusable medical equipment, and a durable medical equipment non-compete would probably not work depending on the wording of the agreement. But more importantly, as this case will show us, sometimes how you word the agreement is more important than anything, and also how reasonable you are in wording the agreement is something that has a big effect on the court deciding the case. So today I'll be discussing the case of Total Quality Logistics LLC versus EDA Logistics LLC and Ryan Daniels. It was decided by the United States Court of Appeals for the Sixth Circuit in 2024. This case involves non-compete agreements in employment contracts, particularly in competitive industries like logistics. It raises important legal issues about when and how these agreements can be enforced, and it has broader implications for employers and employees alike. It's especially noteworthy given the way the anticipated longshoremen strike is apt to affect the logistics industry. It limited the enforcement to a much narrower scope than TQL had requested. The court also ruled against TQL on other claims, such as for damages and for attorney's fees. So TQL appealed, asking for a broader injunction and damages. The Sixth Circuit upheld the district court's decision. The key legal issues in the case are the scope of the non-compete agreement, that's number one, the availability of damages, that's number two, and attorney's fees, that's number three. So with regard to the scope of the non-compete, whether TQL could prevent Daniels from working in the logistics industry entirely, or just from soliciting specific customers. Damages, whether TQL was entitled to monetary damages for its lost business. And on the attorney's fees, whether TQL could enforce a contractual provision requiring Daniels to pay its legal fees. And then the fourth claim, trade secrets, whether Daniels misappropriated confidential information such as customer lists or pricing data. Now, TQL is a logistics brokerage that connects companies that need freight moved with trucking companies. Ryan Daniels worked for TQL as a logistics account executive from 2016 to 2020. When he signed on, he signed a non-compete agreement prohibiting him from working for a competitor or soliciting TQL's customers for 1 year after leaving the company. In June of 2020, Daniels resigned due to disagreement over TQL's return to office policy during the COVID-19 pandemic. Those of you who had worked during that period of time know that a lot of people decided they really liked working from home and they didn't want to come back. Or they thought, it's really dangerous to come back because I'll be back there with all those people who don't cover their mouth when they cough or cover their nose when they sneeze, and I don't want to be back there. So he had this disagreement and he decided, the heck with it, I'm just going to resign. So he started his own logistics company, EDA Logistics, LLC, and solicited some of the customers that he had worked with while employed at TQL. So when TQL found out about this, they went to their lawyers and sued Daniels, claiming that he'd violated the non-compete agreement by soliciting these customers and misappropriating trade secrets. So what TQL argued was that Daniels had breached the non-compete agreement by soliciting customers he'd worked with during his time at TQL. It claimed Daniels used confidential customer and pricing information gained from his time at TQL to compete unfairly. And basically, what the assertion there is, okay, we charge a 5% pass through cost to arrange this trucking thing. We're going to, my company is only going to charge you 3%. They're going to charge you 4%, so it's cheaper to go with me. So that would be unfair competition if you use that information against them. So TQL sought an injunction to prevent Daniels from working in the logistics industry for 1 year, monetary damages for lost business, and attorney's fees based on the agreement's provisions. Well, Daniels admitted he'd started his own logistics company. He couldn't very well deny it. But he argued that the non-compete agreement was overly broad and unenforceable, as it sought to prevent him from working in the entire logistics industry. So imagine you are an emergency room physician and you sign an agreement with a hospital not to compete. You agree not to compete with Our Lady of Perpetual Billing for a period of 1 year. And the agreement basically says you can't be an emergency room physician anywhere in the free world. That's essentially what their agreement said. You can't work in the entire industry. Well, he claimed that that was unfair. He also claimed that much of the customer information was publicly available, and it wasn't a trade secret. And in fact, there are a number of publications of companies that ship goods, Whirlpool, Maytag, all kinds of different companies ship things via truck, sometimes via rail. There are all kinds of ways that people ship this stuff, and as a result, he had access to that just by using the internet. And then Daniels also contested TQL's claim for monetary damages, arguing that their supposed loss of business was completely speculative because they based it on the amount of money that he got working for his own company. Daniels also said, look, it's not directly caused by my actions. They're just not getting off their duff and working. So the Sixth Circuit affirmed the district court's judgment, holding that one, the non-compete agreement was enforceable, but only to the extent that it prevented Daniels from soliciting specific customers he had worked with at TQL. A broader restriction on working in the entire logistics industry was deemed unreasonable, and it would be. It also says, look, TQL, you're not entitled to money damages because you failed to provide sufficient evidence that Daniel's actions directly caused your losses. And the attorney's fee provision in the contract was unenforceable under Ohio law because it was a one-sided clause in a contract of adhesion. Now, what a contract of adhesion is when you go in to, for example, AT&T Mobile and say, I want to get a cell phone, and they say, here, sign this contract, and by the way, if you default on any of your payments, we're going to sue you, and you're going to pay our attorney's fees. Well, you don't have a chance to say, now wait, hold on, I don't think I want to pay the attorney's fees. Can we do something about the contract? Because the people at AT&T Mobile are going to laugh at you, just the way the people at T-Mobile would, or Verizon Wireless would. They have a form contract, and you either sign it or you don't get a cell phone. That's what's called a contract of adhesion, one where the other guy has zero bargaining power, and that's exactly what that contract was. You want to work here, Daniels? Pony up. You got to sign the thing. You got to say you're, going to pay our attorney's fees if we have to sue you. So Ohio law says that's no bueno, and as a result, the court threw out that clause. And then they said that TQL failed to prove that Daniels had misappropriated trade secrets because, again, all of that was available on the internet. On the non-compete agreement, the court reasoned that while TQL had legitimate interest in protecting its customer relationships, enforcing a nationwide ban on Daniels' participation in the logistics industry was excessive. The non-solicitation clause was sufficient to protect TQL's interests, limiting Daniels from soliciting only those customers he worked with directly at TQL. Ohio law requires that non-compete agreements be no broader than necessary to protect an employer's legitimate business interests, and TQL could not prove that its training or industry knowledge was so proprietary as to justify such a broad restriction. With regard to the court's reasoning on damages, TQL sought monetary damages based on the profits Daniels made after he left TQL. However, the court found that TQL had failed to show with reasonable certainty that it would have earned those profits if Daniels had not started his own business. It was unclear whether TQL had made efforts to retain the customers Daniels solicited, and there was no direct link between Daniels' actions and TQL's losses. On attorney's fees, as I mentioned, there's a fee shifting provision in the employment agreement, and it was unenforceable because it was unilateral and it favored only TQL. Ohio courts have ruled that such provisions are not enforceable. Agreements where one party has no real bargaining power or ability to negotiate the terms are not really agreements at all, they are dictates. So, for the record, Ohio is ahead of the curve on this, and I believe this is an excellent policy choice by the state of Ohio. On trade secrets, TQL argued Daniels had misappropriated its customer list, but the court found that the customer information Daniels retained was publicly available and easily discoverable through legitimate means such as cold calling. Additionally, TQL failed to show that Daniels had access to or used any proprietary pricing strategies that would qualify as trade secrets. The case has significant implications for both employers and employees regarding non-compete agreements. First of all, the scope of the non-compete agreements is an important factor. The ruling reinforces that non-compete agreements have to be narrowly tailored. Employers can't enforce broad restrictions that prevent a former employee from working in their industry entirely, especially if the employee's work does not involve proprietary knowledge. Challenges in proving damages. Well, employers who are trying to seek damages for violations of non-compete agreements have to provide clear, concrete evidence that the employee's actions directly cause financial harm. Speculative or circumstantial evidence will not suffice. This is a reason why, in many cases, employers will use what's called a liquidated damages clause. And the liquidated damages clause says something like this: because it is impossible to know going forward what our loss would be if you breached this agreement, you agree, as a condition of signing this agreement, that you will pay at a minimum $100 a day for every day that you are in breach of this agreement. That's a legitimate liquidated damages clause. If you said you're going to pay $1,000 a day for every day you're in breach, well, that then looks too much like a penalty, and a court will not enforce a penalty. So when lawyers draft these agreements, they have to be very careful in crafting a liquidated damages clause that closely approximates what a company might lose and be able to support it with evidence at a trial. And of course, here they just didn't support it with any evidence at all. And the limits on the trade secrets claim. Customer lists and pricing information may not always qualify as trade secrets, especially when they can be easily obtained through publicly available means. Employers need to demonstrate that such information is truly confidential and that they take reasonable steps to protect it. In other words, they don't grant access to the entire office. They keep the names and that sort of thing, if it's a customer list, in a locked binder in the safe. They only communicate those things to individuals. If you have 5 different salesmen, well, every salesman only gets 1/5 of those proprietary names. That's how you show you protect a trade secret. In summary, Total Quality Logistics LLC versus EDA Logistics LLC and Ryan Daniels provides some valuable insights into the enforcement of non-compete agreements, particularly in Ohio. The case illustrates the court's careful scrutiny of such agreements to ensure that they are reasonable and not overly restrictive. It also serves as a cautionary tale for employers to be diligent in proving damages and protecting trade secrets if they want to prevail in similar disputes. So that's what I have for you today. I thought it was an interesting case. I hope you find it so. If you have any comments, drop them in the comments down below, or you can email me at the address above. As you know, we always ask folks to do a kindness for someone today, even if it's only opening a door. After you do that, come on back tomorrow, join me down here at the beach, and we'll talk about something else on the law. Hey, as I said at the beginning, none of what I said is legal advice, but let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.